want to be understanding, but I'm not going to be. There's no reason why you didn't bring it up here. You're not entitled to another adjournment. Counsel, how much is owed on this?
Your Honor, I don't have the current ledger on me. I'm personally okay to do an adjournment. They did show me proof. They emailed me
We're going to
proof
bring
that
it up to the court today. Okay?
I did let them know that they need to fill out that DC 539 form, I believe it's called, to let you know as well.
You need to bring this up here today, young lady, and Mr. Teamer.
Okay.
Do we understand one another? I don't want to have to beg people. Please, you got to bring it up here today. Today.
Okay.
What date am I giving them, Jennifer?
Would you like 1 week, sir, or 2?
I'll give them 2.
Okay. We can do April 27th. How about 9 o'clock, sir?
Now, I'm telling you right now, I have your word. You're bringing this up today, right?
Yes, sir.
This morning, right now, right?
Yes, sir.
And you haven't heard from the funding unit?
I have. I'm waiting on one paper for
What did
my
they
job.
say to you?
They told me I had to upload my verification of employment. That's the only thing I'm waiting for. And I'm trying to get that today.
All right, you get over here with your paperwork today. We'll make it April 27th at 9.
Your Honor, if I may, I believe they have transportation issues. Would they be able to email the court their proof of application?
How they get it here? Jennifer, what do you want them to email it to?
Your Honor, go ahead and have them email it to Jennifer's email. So jen@33court.com.
Jen@33court.com. You can send it over. You know how to do that?
Yes.
Okay, send it over now and you're all set and I'll see you in 2 weeks, but follow up with the funding agency today, okay?
Okay.
Thank you. Good luck.
No problem.
Owners Management versus
Thank
Jill
you.
Bordine, 2601161.
Morning,
Your
Your Honor.
name?
Attorney David Lackner, P number 67994 on behalf of Owners Management.
Your name?
Jill Bordine.
All right. Did you provide us with proof that you made application for funding?
I was not able to get down to the court to show it because I didn't get it in. I didn't have any proof to show within those 5 days, but I do have the proof on me now showing that I did apply and I was denied.
And you were denied?
Yes.
All right. Well, tell me how much is owed, Mr. Lechner.
At this time, because last time we were here, it was March 30th, so April's rent is now due and owing. So 3 months of rent due and owing is $3,045. There are late fees due and owing of $64 and court costs of broken out court filing fee, $147.29. Proof of service 42 cents and statutory attorney's fees
42 cents or
$75.
$42?
$42, excuse me, sir.
Okay, go ahead.
$42. $75 statutory legal fee for a total of $264.29 in court costs, making a grand total $3,373.29.
You agree that you owe that amount?
Yeah. Yes, Your Honor.
Your Honor, I spoke with Ms. Bordine in a breakout room. We've come to an agreement to enter a conditional dismissal. The terms of that dismissal are going to be she agrees to pay the $3,373.29 or vacate the unit on or before April 30th, 2026. If she does either of those things, the dismissal stays. If she doesn't, my client will let me know, and I'll file to reopen the case. I told her I'm going to check
You break
box.
for a money judgment here too, you know.
Yes.
Well, what if she just vacates? Is the language in the conditional dismissal, does that reflect that she'll still owe a money judgment? 3,373.29?
If she vacates, if she vacates properly by April 30th, I'll put in the judgment language that she doesn't owe the money.
Okay. So you understand that, Ms. Bordine?
I do, Your Honor.
So the total amount, this will be a dismissal. You can either pay 3,373.29 by April 30 or vacate by April 30. If you vacate, you will not owe in a money judgment that amount. and the dismissal will remain in full force and effect. But if you pay up, obviously, the case will remain dismissed and you can stay in the property. Do you understand that?
I do, Your Honor.
Since you're unrepresented by a lawyer, you have 3 business days to come in here and fill out a motion to set aside this dismissal. And you have 10 days to appeal. Do you understand that?
I do, Your Honor.
Does Mr. Lechner have your permission to sign your name to that proposed conditional dismissal?
He does.
With those terms being incorporated.
Yes, Your Honor.
Do you have any questions for me at all?
Not at this time.
Your Honor,
Okay.
I just want to put on the record as well that I'm checking box 4B, which, and I've explained this to Ms. Bordine, but for the record, that if she doesn't, if I have to reopen the case, we're not going to a hearing. We're entitled to a judgment upon reopening the case. I'm also checking paragraph 7, which shows that a partial payment is not going to forestall
You
the
can check
eviction.
that, but I have a problem with you saying I don't have to set it for hearing. What do you use the word properly vacate? I don't know what that means. I guess I could guess at what it means, but I don't want you guys being judge and jury as to whether or not she vacates properly. So if you're going to seek a money judgment because she didn't quote unquote vacate properly, you're going to have to file a motion and we're going to have a hearing.
Understood, Your Honor.
So do you understand that, Ms. Bordine?
I do, Your Honor.
Leave the property in good shape, take all your belongings out, turn over the keys, and leave with the understanding that there will be no money judgment as long as you've left the place in an acceptable condition and you've taken all of your property out of there. If you haven't taken things, then you're not going to really be able to argue that you vacated. So if you leave a couch or chairs that you don't like, you really haven't vacated. Okay, do we understand one another?
Yes, Your Honor.
Okay. All right, good enough. So you can submit that, Mr. Lechner, and you're all set. Thank you.
I will do so. Thank you, Your Honor. Thank you,
Good
Ms.
luck,
Bordine.
ma'am. Thank you.
Thank you, Your Honor.
We don't have granite yet. It's,
Without having the 10 funds.
wow.
Your Honor, I do have Granite Televalley in the waiting room. I can bring her in, and we do have Mr. Bogis's sister here in the courtroom. If you'd like to call that, that's up to you. I don't have any of the other 10 o'clocks ready yet.
You can bring in granite Televalley. Wow. What happened? There must have been a lot of dismissals. We got quite a small docket this morning.
There weren't very many filed, but in addition to that, yes, we had many dismissals on Friday.
Granite Televalley versus Ronald Allen Bodges, 2600001. You want to come up here?
Yes.
I can't let you represent him, but I want to find out. Stay seated. Is Granite Televalley in here yet? People against Andrew Joseph Ellis Webb, 26B82402A.
Good morning, Judge. Nice again, and behalf of Mr. Webb, rep to the full name. Andrew Webb.
Were we?
I don't even want to make an excuse. I wrote on my calendar the 18th, totally made a mistake. I realized at 5 o'clock on the 8th. It was actually my birthday as well. About 5 o'clock, I got done working, realized it was the day. I had a real early pour in the morning. Thursday couldn't make it. Came Friday, but couldn't see it.
Heather, I want to make sure the victim didn't well, I'm going to have to do this over. Reschedule sentencing. Notify victim. I don't remember enough about this one, but I would have read the police report that day. But it, there was an order on here for me to forfeit your bond. I'll give you April 22nd, 8:30.
Okay,
Take the notice,
okay.
tape it to your refrigerator.
I want to apologize again. I'm very
All
sorry.
right, good. You don't have to grovel. April 22nd, 8:30.
All right.
I'll see you back here then. Good luck.
Thank you.
You had another misdemeanor, right, Mr. Gabe?
I'm sorry.
Didn't you have another misdemeanor?
Yes, it was,
Okay, I'll take that one.
I believe, Mr. Hayner.
People against? Gary Allen Hayner, 23B, 1433588 and B.
Yeah. Well, can I get the parent back, Mr. Hayner? Mr. Hayner, say your full name. Gary Hayner.
All right, so what is he going to do?
Judge, he'll plead guilty to the failure to comply. He was sentenced on this case back in 2023, Judge. Mr. Hayner was having some personal problems, well, some financial issues. His main issue was financial. His children's mother had suffered an injury at work. And
All right, let me just take the plea first and then we'll go from there. Okay, and you can allocute then, okay?
Sure.
So, sir, you have a disorderly person, public intact. You have a resist and obstruct an officer. I sentenced you on these back on August the 2nd of 23. You were then supposed to be here for a show cause because you failed to enroll in on-site testing. And you were supposed to be there and enroll on August 4th. We set a show cause. You didn't show up for that on August 22nd. So that is the charge. Failure to enroll in biweekly chemical testing is ordered on August the 4th of 23. Do you understand the charge?
Yes, sir.
If you plead guilty, excuse me, or if you are found guilty, I do want you to understand this is a non-technical violation here since you did not show up. You've absconded for more than 90 days. So you could get, or for more than 60 days, I should say, I apologize. And you could have your probation revoked and you could get 90 days on each of these charges. Do you understand that?
Yes, sir.
All right, did you sign, read, and understand and advice of rights form here today?
Yes, I don't know that it's not. Did you sign a double sheet, sir, saying that I mentioned this? No. Judge, you just have a minute, I mean,
Sure. Take your time. We'll go off the record. John, call up Beth, tell her we're gonna need somebody on this case.
Okay.
Hayner. It was Emily's.
His last name is
Hayner, Gary Hayner, H-O-E-N-E, Gary Hayner.
still timeless. He's still the house case. Yeah, okay.
All right, so sir, let's go back on record. Mr. Hayner, have you now had a chance to review the advice of rights? Did you sign it?
Yes.
Did you understand it?
Yes.
Did you go over it with your lawyer?
Yes.
If you plead guilty here, you're going to be giving up all these rights and we're not going to have a hearing of any kind. Do you understand that? All right. And you understand you could, since you've absconded, this would be a first technical violation. But since you absconded, you could get 90 days on each of these files. Do you understand that?
Yes, sir.
All right. You still wish to plead guilty
Yes.
to the charge that you failed to enroll in biweekly testing by August 4th of 23. How do you plead?
Guilty.
Did you fail to enroll in biweekly testing by that date?
Yes, sir.
And you were told by the probation officer to enroll, true?
Yes, sir.
And you failed to do so? You just absconded then, right? This was the day after the sentence and you decided you weren't going to do anything?
Yeah, if I,
Is that, I just want to know, is that true?
Correct. I was captured and I didn't have a license. I didn't have anybody, like any family support. So I was kind of like flying by the seat of my pants. So maybe, yeah, like I didn't have a way to do.
Anybody force you to plead guilty?
No, sir.
All right, I'm going to accept your pleas. Now, what would you like to say, Mr. Gay?
Judge, just that, like I mentioned earlier, it was an issue of finances at the beginning. He did not have a valid license. He didn't have a stable place to stay because he couldn't afford to pay rent. Majority of his money was to help the mother of his children, but suffered a back injury at work. So in addition to having to pay her child support, he was also picking up some of the additional expenses for the household. And because he does share two children with her, 15 and 16, I believe, is that correct?
Yes.
And so at the time, not only was he unable to come and go, even if he had a job, Judge, but any money that he did have went to trying to help keep that household in place and keep them at least somewhat solvent at this point, because there was no money coming in on either side. Judge, he did walk in on his own, so I'd like the court to consider that. And he is able to pay the entire amount of the balance due today, Judge. He is also, since then, he's had no run-ins with law enforcement whatsoever. He's trying to resolve all of his outstanding issues, Judge. He's full-time employed at B&D Cold-Headed Products in Wayne City. He's been employed since 2018 with just some gaps in between that and what that wasn't steady employment. One of the gaps would have been right around the time that he caught this case as well, Judge. But now he's back to full-time employment. He does work the night shift, so he's able to clear as far as any balance is due, and we'd have the court to take that into consideration, Judge, even present.
Where are you working now?
Work at B&D, drug roller, B&D Cold-Headed Products. It's off of Van Born and Wayne, Van Born Road in Wayne.
In Wayne City.
Yeah, it's outside of Ryan.
Swells?
Elizabeth Ostration, Your Honor.
Anything at all?
I was just reviewing the file, Your Honor. We didn't get noticeable warrant recall. It looks like Miss Tessino, who was supervising him at the time, met with him, got him instructed, and then essentially absconded right after that. The only thing I would have to go back in my office and check on is see, not sure if it was mentioned, if he did any of his court work program days. He was scheduled, but I would have to look at those sign-in sheets in my office, Your Honor. But other than that, again, there is no verification of treatment, 12-step meetings. The test that the violation was issued for was his initial test with onsite. So it looks like from the beginning he absconded, Your Honor.
Right.
Judge, I don't believe, my discussions with Mr. Hayner, I don't believe that he's done any of these.
No, it was, I sentenced him on August the 2nd, and he didn't enroll by the 4th. And that's when he just left. He just decided, for whatever reason, I don't care if it's, didn't have a ride. You just can't do this.
I did turn myself in other cases. I was in, did some time around that, right around this time too. I was in Wayne County and on probation for them from the district court since, for 2 years now.
Out of the Third Circuit Court, you mean?
Yes, yeah.
Right,
For
because you had a felony.
the child support, Judge.
Yeah, and I took care, I had stuff in enroll, I went and took care of, turned myself in, and I had a bunch of other deals I was taking care of too, and this, I don't know, it gets a lot on my plate. Doing the best I can, I'm trying to take care of it now. I'm doing the best I have done.
I do have a screening, Judge, if you can see it.
Please. I mean, I see why I did what I did.
A lot of mistakes there, so I'm trying not to go down these roads anymore.
How much is owed on? Can you tell me?
76.
983 and 276. So he has $1,214 on, right?
You can pay that today.
I paid 900 today. That's when we made the phone call, I went to the probably get to all 12. Was in there, impression, it was like 880.
It was, the file said 840 at the time.
You just can't do this. Probation's revoked. You're on the disorderly person charge. You're to pay costs of 900 and serve 90 days, credit 1 for 89. If you pay 900, I'll suspend 59 of the 89. You'll only have to serve 30. On the R and O charge, same thing. Probation's revoked, you're to pay costs of 200 and serve 90 days, credit one for 89. If you pay 200, I'll suspend 59 of the 89. You'll have to only serve 30. So you have to give them $1,100. You have 21 days to appeal. Here you go, lady. 14 days to apply for a court-appointed lawyer for purposes of appeal. I wish you well. They'll let you make a call. Just can't. It's good luck. Thank you. Here you go, Amy. Granite Televalley versus Ronald Allen Bodges, 260001. Come on up here, ma'am. Good morning, Mr. Landman. Your appearance.
Good morning, Your Honor. For the record, Daniel Landman, P35797, appearing on behalf of the plaintiff.
Mr. Bodges' sister is shown up here. I'm not sure why. I'm gonna at least ask her to identify herself. Come on up to the podium.
Oh.
That's the podium there. Your name?
Michelle Bogus.
Where is he?
He is in the hospital. I went up to the desk and gave them the paperwork from the doctor, went through the emergency room. He is going along rehab. So all his rent is all paid up. There's a copy of that there as well. With her signing off on it and the receipts.
So, Mr. Landman, this is the one I was a little curious about. They started not only the termination action, but a non-payment action. If you'll bear with me, I think this is what happened is I stayed this case because this has to do with failure to comply with community rules. And he's charged with felonious assault. So I didn't per se stay it, but what I said is I don't think it's fair. He's got a felony pending, and I'm not going to have somebody in a civil case without a lawyer incriminate themselves. But in the meantime, your office did a non-payment rent case. I'm pretty sure, don't quote me, when I get rid of a case, I forget about it. But I'm pretty sure, unless your records will reveal differently, that I gave you guys a judgment with a writ date, and it sounds like Mr. Bodges has paid that now. You heard what his sister just said. I'm sorry, ma'am, your first name again?
Michelle.
Michelle. So my inclination here is for us to double check on that. Jennifer, are you out there? Yeah, would you do me?
Your Honor, the property manager is present and raising her hand, so she may be able to give us some insight too.
Okay, thank you. Wait one second, Ms. Bryant. Jennifer, would you check on that? I'm pretty certain that I'm right on that. Ms. Bryant, you can unmute and tell me your name.
Suzanne Bryant for Granite Televalley. Yes.
Is my recollection correct?
Right. He had a writ date of the 8th and he paid by the 8th. So it was all taken care of.
I don't think I can proceed on this termination action anyways. I mean, I don't think I can do that if it's solely on the basis of committing an assault on another resident. I don't feel comfortable with it. I got a guy here that's charged with a 4-year felony, and if he did it, I don't have any remorse for him, but I still have something to do here and that is to protect people's rights, and I can't imagine me forcing somebody to go through with the hearing. So I can do one of two things for you. I can adjourn this again, but I'm not going to set a hearing date until there's a resolution of the felonious assault case in circuit court. So I'm inquiring whether or not you may be willing to dismiss this and refile when that issue is resolved. Ms. Bryant, you had your hand up again. I can't change my mind on this. I want you to understand. I won't. But go ahead. What do you want to say?
Your Honor, if I may, before Ms. Bryant, firstly, which hospital is he in right now?
He's in the Heritage Hospital on Telegraph Road. When I came in, I went to the desk and they have all the paperwork that's notarized, signed by the doctors, all the receipts.
Who has it?
Pardon me?
Did you go to Heritage or did you bring the paperwork here?
I took him to Heritage, then I came here.
I know. Where's the paperwork?
Yeah,
Your Honor, it should be in your file. We did bring down a copy.
Yeah,
Oh,
I brought them.
so it just said he's admitted on April 12th and will remain inpatient until medically cleared.
Yes.
So did you want to say something else?
Your Honor, I do need to make a record on this.
And you're going to say how why
As the court is aware, the standard in this particular
I
case
know.
is a civil standard, which is
I
weight
know.
of the evidence.
I know.
The problem that the concern that I have is I have a history, not with this particular individual, but in a different court, in a different case with a similar situation, that being a tenant that was charged with an assaultive crime. There was a delay of approximately 3 years from the date of the offense until the termination case was actually heard.
The same reason that I'm mentioning, though, right?
But under no circumstances is my client going to dismiss the case and then turn around and have to file a new 30-day notice whenever these other proceedings are concluded. My recollection is that in this case there may also be a competency situation, and the last thing I want to see is this case delayed while we're waiting for the defendant to be competent to stand trial in the criminal case.
What do you want me to
also
do,
the
though,
possi-
Mr. Landon? Tell me what you want me to do. I can't
Well-
proceed.
But I see two possibilities, Your Honor. Well, three possibilities. What we would prefer, obviously, is for a trial date to be scheduled. That not being an option, then there's two ways to go. We could do a conditional dismissal with the tenant agreeing to move out by a date certain. We're not able to do that today, obviously, because he's not here. The other option is to, again, adjourn and get a new date. And if the tenant is willing to vacate, we can get a conditional dismissal in before that date.
It doesn't, well, he's got to agree to a conditional
He
dismissal,
would,
right?
yes, that's correct. And obviously, you can't do it today because he's not here.
There is no way I can go ahead and proceed with the trial on this. I just am not comfortable with that. I'm not even sure I don't believe now I could be wrong. He just paid the money on a non-payment case. That signifies an intent that he has no intention of leaving.
Well, he's also required by statute to keep his rent current while the termination case is pending. And that's 600 MCLA 600.5779.
I get all that, but that tells me he doesn't want to leave. Right? I mean, if he wanted to leave, he would have not paid his rent and just left, right? So I'm pretty confident when he comes back here next time, he's going to tell us that he doesn't want to leave. I am not going forward with a trial on this without a resolution of the Wayne County Circuit Court action first. I'm just not comfortable with it. There's no way I'm doing that. That's not fair for me to do that. He might be not the best person in the country, but you know what? He has rights and I'm not going to violate them. So what am I supposed to do? Keep a landlord-tenant action open, like you say, for 8 months? I mean, I guess the Supreme Court is going to come down on me thinking I'm fooling around down here, but that isn't the case. And I can't enter a stay of this and have the time guidelines stop running, or I would. So I'm not quite sure what the answer is, but
I think he has a trial date. Currently, there's a trial date, I believe, in July, but I don't know what the competency ruling of the decision is going to be between now and then.
And that's probably going to get delayed because the competency exam staying everything else essentially. They're not pre-trying it. They're waiting for the report. I'll adjourn this 2 weeks to April the 27th. Jennifer, is that right?
That is correct, Your Honor.
At what time? 8:30?
No, let's do 9:30, please.
Okay. 9:30. I'm just asking you guys to put yourselves in my position here. I would waive any filing fee. Obviously, if you agree to dismiss this, I can't do anything about the 30-day notice. Although maybe I can figure out something. At any rate, you guys come back and I'll see you on April 27th on that one, okay? And then you can
And Your
tell
Honor, in
Mr.
the
Bodgett-
meantime, if the court can, I don't know if the court has any information that's available to the court and obviously not available to me with respect to the status of the competency evaluation. I'm assuming that this gentleman has counsel in the criminal case, perhaps court appointed, but I would also expect that that case is at least moving forward to some degree, and that a competency evaluation would have taken place or would be scheduled rather than the case just sitting fallow.
No, I think the problem with the competency exams, I don't think you do a lot of criminal. The problem with those is that they get scheduled, especially for somebody who's not in custody, a couple months down the road. And that's always the difficulty there. Now, he told me, I think it was just one of the last couple of times that the competency exam had been ordered. So maybe there was a delay in doing that. And
Your Honor, Ms. Bryant has contributed and indicates that there is a competency exam scheduled for May 23rd.
right.
So maybe April 27th is not a great date to put this out. Maybe we put this out until after the competency exam.
Competency exam, by the time they get the report, it's going to be June the 10th. I want to think about this. I'm going to still keep it on for April 27th. You'll have other ones that day. I might dismiss this on my own. I don't know how I'm going to handle it. I'll think it through. Good luck. I mean, I can't do that really, but maybe I can come up with something that's creative. Have a good day. That's what I'm doing. Thank you. Granite versus Seth Lawrence Bremer and Sibel Jane Justice, 2601459.
Daniel Landman, Your Honor, on behalf of Tell Valley.
Do I
And
have any?
No, Mr. Bremer and Ms. Justice did not appear with me, Your Honor.
And you paid for a second mailing. This was a first appearance. You can go ahead with a default.
Thank you, Your Honor. Plaintiff does respectfully move for the entry of a default judgment for possession. Rent to retain, Your Honor, is a total of $1,569.48, made up of $1,499.48 in rent and $70 in late fees, representing 2 months at $35 a month. Filing and service fees are $176.07, and the statutory attorney fee is $75. And that adds up to a grand total of $1,820.55. We'd request a writ date of April 23rd.
Defendant failed to appear. Writ date will be April the 23rd. The amount to be paid to save it from the issuance written, the judgment amount is $1,820.55. Granite versus Tammy Charity Deronda Siggers and Joshelle Sky Gerwitowski, 2601460. Are any of those individuals here, Jennifer?
Your Honor, they did not check in with us.
Paid for a second mailing. You can take a default on this one.
Thank you, Your Honor. Based on my client's books and records, total rent to retain is $1,554.59. That consists of rent of $1,484.59 and 2 late fees of $35 each for a total of $70. Filing and service fees are $176.07, and the statutory attorney fee is $75, resulting in a total of $1,805.66. And again, we request a writ date of April 23rd.
Defendants failed to appear. The relief request will be granted. That is a default judgment of possession in favor of plaintiff and against defendants. The writ date in this case will be the 23rd of April, 1805.66 is the amount to be paid to save it. Granite versus Maurice McGee Jr. and Angelica Marcia McGee, 2601462. Okay, Mr. McGee, I need to see you better like that, sir. You gotta, you're not in a moving car, right? No, you wouldn't do that, right?
No.
What's your name?
Oris McGee Jr.
Where are
Oris
you?
McGee Jr. I'm parked in my car. I'm at work, but they've given me leeway.
Where's Angelica McGee at?
She's actually at work. She wasn't able to appear with me today, but I'm representing both of us. That's my
You
wife.
can't do that though. I'm just telling you, she's going to be defaulted. She's got to show up. First of all, did you listen to and understand the rights?
Yes.
And do you wish to speak to a lawyer?
If possible, like to speak with the landlord, we could possibly
Yeah,
settle
I
something.
can let
with
you
the
do
payment.
that, but I'm asking, do you want to speak to a lawyer and do you intend to apply for funding?
No lawyers needed.
And you're not applying for funding?
No, not at this moment. No.
Why don't you give me the total amount, Mr. Landman, please, that's due?
Absolutely, Your Honor. Without giving the breakdown, based on my client's books and records, there is a total of $1,884.85.
You agree that you owe that amount, Mr. McGee?
Yes.
And when can you pay that by the 23rd?
Let's see. I can pay about 800 of that today. Actually, I can pay 1,000 of that today, and the remaining amount I have to see. I get paid bi-weekly, so I'm just
What day
trying
do
to
you get
make
paid
sure
of
I
the
got
week,
this
sir?
correct.
What day do you get paid?
I'm checking now. It
Just
would
tell me, is
be
it Mondays, Fridays? What is it?
Fridays.
So you got paid last Friday?
Yes.
So that was the 10th. So you're going to get paid on the 24th. How about if I do
Yes.
this? Mr. Landman, any objection? Here's what I can do. I can enter this judgment for 1884.85, and I can say if defendant pays $1,000 by April 23rd, writ date extended until the 27th. Is that acceptable, Mr. Landman?
Ms. Bryant, what do you think? She's nodding.
Yeah.
Yes. Okay, so you want to do that, sir?
Yes, that works.
So I'll do that after a hearing today. I'll enter a default against your wife. That is your wife, correct?
That's correct.
Judgment after hearing versus you. If defendant pays, and the total amount is 1884.85, and if you pay that as follows, 1,000, no later than the 23rd, I'll give you until the 27th to pay the balance. Fair?
Yes, that's fair. Thank you.
All right, so we'll do that. You can submit the order, Mr. Landman, and you don't have to, we're not going to do it as consent or anything. That's after hearing, okay?
Very well, Your Honor.
Any questions, Mr. McGee?
Not at this moment, no.
I wish
Thank
you
you, Your
well.
Honor.
Thank you.
Thank
Good luck. Granite Televalley versus Timothy Scott Stevens, 2601465.
Your Honor, he did not appear with us.
All right, so that you got a second mailing on this, you can take a default.
Thank you, Your Honor. Based on my client's books and records, there's total rent to retain of $825.30. That consists of rent of $790.30 and one late fee of $35. Costs are $116.36, and there's a statutory attorney fee of $75. We're requesting judgment in the total amount of $1,016.66 with a writ date of April 23rd.
Defendant failed to appear. The relief request will be granted. That is default judgment in possession in favor of plaintiff and against defendant. Writ date will be on the 23rd. The amount to be paid to save it is $1,016.66. So the writ date will be on the 23rd on it. Do you have any others with me today?
Your Honor, I believe my other cases with you this morning were dismissals. Have a wonderful day, and we appreciate your consideration as far as the Bob Bogus case.
Thank you very much. Have a good day. Thanks, Ms. Bryant. Okay, Preston Point versus Rajon Dell, 2601466. Mr. DeRozak, how are you?
Good, Your Honor. Good morning. Mike DeRosak on behalf of the plaintiff, Preston Point.
I haven't seen you in a while.
It has been a bit, yeah, covering for Phil this morning. He's got a conflict.
What are you, have they elevated you to senior status or something? Or?
Only the gray hair makes it look like that, Judge.
I'm
Mr. Dale, by the way.
How you doing, Mr. Dell? Good?
Hey, how you doing?
Tell me your name, please.
Ray John Dale. I got it. My nickname is Ray Dale. My bad. I forgot to change
You're
it off. My
fine. You're
apologies.
fine. If that's the worst thing that happens on Zoom today, that's fine. Did you listen to and understand the rights on the video?
Yes, sir.
And do you wish to speak to a lawyer or apply for funding?
No, sir.
Okay, Mr. DeRozak, this is for non-payment, right? Yes, it
That's
is.
correct.
So why don't you just give me the total amount that's due right now?
The total all in, Judge, we have $3,814.56.
You gonna be able to pay that, Mr. Dell?
I got a cashier's check right here for 2,200, and then I get paid every Friday. So I should be able to catch the rest of the remaining balance if I can pay the 2,200 today cashier's check. Drop it up to my office if I could do that.
I can do that for you,
Yeah.
Mr. DeRozak. Here's what I'm gonna do. I'm gonna let you prepare the judgment. This will be after hearing. If defendant pays 2,200 by the 23rd, but take it up there today, okay? I'll extend your writ date until the
Okay.
27th, and then you should be able to pay the balance, right?
Correct.
Or I want to
So
make
if I
sure.
pay the
2,200
yeah,
goes
I'm making sure too.
1614.56.
Oh yeah, if I can get to the 27th, I can have it paid before the 27th and have my new rent paid on the 1st.
Fantastic. So why don't we say, if defendant paid, yeah, I'll give you till the 23rd to pay, although I think you should just bring it there today. And then the balance, if you pay by the 23rd, $2,200, writ date extended until the 27th. Okay? Is that
All right, that
fair enough,
sounds fair.
Mr. DeRozak? Are you good with that, or you want it to word?
That's
Pardon?
fine, Your Honor. Did you want me to set this up by hearing or by consent? What do you prefer?
I think just after hearing.
Very
I
good.
think after hearing.
So I'll
You-
be able to drop this off as soon as we get off the phone, Your Honor.
Yeah, bring it over there today. He's going to bring a judgment over. He's going to send me a judgment today. And then you just have to pay the
Okay.
remaining balance, which again will be $1,614.56 by the 27th. Okay?
All right.
Good luck.
1624.
What's that?
You said 1624. I was making sure I got the right
No,
amount,
I said
the correct amount.
1614.56. After you pay the
Okay.
2,200, you
Okay.
have to pay 1614.56 additional by the 27th.
Okay, cool. That sounds all right.
All right?
Appreciate it.
Good luck.
Yeah.
Thanks.
I appreciate it.
Preston Point versus Chanel Himes, 2601467. Good morning, ma'am. Your name, ma'am?
Chanel Himes.
Okay, you got to keep your voice up for me, nice and loud. Did you listen to and understand the rights on the video?
Yes, I did.
You wish to speak to a lawyer or apply for funding?
No, no, sir. No, Your
Mr.
Honor.
Drozak, your appearance?
Good morning, Your Honor. Mike DeRosak, appearing on behalf of the plaintiff, Preston Point.
How much does she owe in total?
In total, all in, we have $2,686.94.
Can you pay that, ma'am?
No, that's not correct. It's 12/14/25. As of March 26th with the fees. And then for April, it is with the fees 508. And it should make it like 1722.25.
Wait a minute. He's indicating a rental rate on his complaint of $1,450.
Yes, but there was a subsidy for that. So the amount was
Well,
only
but they don't
383. I'm
have to
looking at the
include the sub.
ledger. I'm sorry. Say
They
that
don't
again,
have
sir.
to. They don't have to include the subsidy in their amount if the.
Okay, I'm basing it off of what I received in my door. They're gonna
Hang
still
on,
receive.
slow down 1 second. 1 second.
Yes,
What
sir.
was the total amount owed as of March the 26th, you said?
On this ledger I received in my door with the court, it was $1,214.25.
So, but they're entitled
That's
now
what-
to the 1450, right? Plus a late fee for April, right?
This was just through March, and then April would be 383 is my portion, plus their $125 late fee. So
Have they
that would
been
be
paid?
another.
Have you guys received I don't know who the subsidy is coming from. Have you received any payment from them?
We have not received a payment, Your Honor, since March 9, according to the ledger.
So on my math, You got 2664.25 plus a late fee. I don't know. I think they shortchanged themselves.
No, the total amount should be, Your Honor, because it was the note in my door was for the 965.25, which was correct with their late fees. Then they added 250 in legal fees on the 26th of March and
Well,
the
what are your late fees?
$50 a month, Your Honor.
The late fee, they're charging $50 and $75. And so 125 a month in late fees each month. $249 in legal fees. My rent is $383 for the month of
No,
April.
but your rent isn't $383 if it's $1450 and the rest is being paid by somebody else.
It's being paid by the veterans program, the veteran housing program.
All right, let's
So
slow
they
down.
pay the
Let's
HAP
slow
program
down
pays.
here. Let's slow
Yes,
down
sir.
here. Let's slow down here. You know, I'm not going to give you $125 a month in late fees. I'm going to give you $75 in late fees at maximum. The complaint says the monthly late fee is $50.
That's what I have written down for my review of the lease. I don't know that they actually charge this 125 that Ms. Himes is stating, but I'm happy to
It is charged. It's
to
in the
review to
ledger
make
that
sure that it's not in there. Judge, I know we can't do 125 in your court.
So
it's in the ledger. I'm looking
Wait a
at the
minute,
ledger,
ma'am.
Your Honor.
Wait,
that I guess the
please
bailiff put on the
stop.
door.
You're really interrupting now. Please.
I
I'm
apologize.
trying to get to the bottom of this, and you want to keep insisting that your portion of the rent is only $386 or whatever you're telling me. That's great, but they have the right to charge any balance on this account. So if you owe $1214.25 and the rent, if it's true, is $1450 per month, whether it's coming from you or the veterans program, it's $2664.25 plus a late fee of $50, and that's $2714.25 plus any cost. So I don't know why you're saying you only owe $1,500 or thereabouts. They're entitled to charge that if they haven't received it from the veterans program. It's incumbent upon you to call them up and say, listen, they're going to throw me out of here if the judge doesn't, if you don't make this payment for me. So he's an officer in the court. He's not going to lie to me. If he did, he'd have big problems. Plus, he's never lied to me before, and I know he wouldn't lie to me now. And he's not going to tell me that they've not received the payment from the veterans program if they've received the payment from the veterans program. Now, I want to work with you. I want to work with you and help you make this payment if I can. I certainly want to do that for you, ma'am. But we got to get past what is owed first. And I'm not quite clear why you're telling me it's only $1,500 or something, because they don't have to take into account.
Yes, sir.
Well, tell me now. I've explained to you, but
Okay,
I don't want to argue about this either.
No, I'm not. I promise you I'm not, Your Honor. I'm at work right now at the VA, and I'm just trying to explain what I received in my door. I've never received a ledger before. I'm holding the whole packet that came in the door with a ledger that I've never seen before attached. And at the bottom of this ledger that they printed out, that I guess the bailiff or whomever put into my door, says March 26th, the total fees due is $1214.25 through the end of March.
Yeah, but your April rent's due now.
I understand that, but what I was trying to explain to you, Your Honor, was that they receive a check from the HAP for the subsidy. It says Section 8 HUD rent as a HUD BASH program as a vet. Okay, they may not have received that payment yet, Your Honor, of 1067. That could be why they're factoring in it being 1450. That's what I was trying to explain. But at the end of this ledger, it's saying I owe 1214.25. Then for the month of April, my portion of that subsidy, Your Honor, will be 383 plus their $50 late
I'm
fee
trying
plus
to
their
tell you,
additional
I'm not just
$75 late.
including your portion. That's not fair to them.
They're going to receive their payment from that program. They have in the past, and they will continue to do so. And it comes after my portion is paid. That's what I was trying to explain to you, Your Honor. So that's why I was saying they're going to still receive that 1067. I understand you're factoring it in, but
Your Honor, I expect that we will receive the 1067. Of course, I have no idea when that will be. I have no problem extending the writ date a bit if that would give Ms. Himes some comfort. That would give additional time for
Well,
that
that's what I'm trying to
subsidy to be
do,
made.
but I don't want to keep going through this. I mean, I don't understand why you're even at only 2664, 20, whatever you told me, 2686.94. You should be more than that. But
No,
I
it
don't
shouldn't.
know. I'm good to give you the 2686.94 because I'm convinced that you're at least entitled to that. And
I
if I
don't
do
owe
the math on this, including your
26.86.
filing service and statutory attorney fees, you're going to be closer to $3,000. But I'll give you the
I don't owe that.
2686.90.
I don't owe that.
Why are you shaking your head, ma'am? Why are you doing that? I don't want to argue with you.
No,
They're
I'm
in,
not. My portion total, Your Honor, as of today, Your Honor, with April's rent and the late fees would have been 1742. And I understand you're factoring in at 1450, but they're going to get the 1067 for the month of March and the 1067 for the month of April from that agency. So based on this ledger, I have the 121425 through the end of March 26. I was just going to ask for an extension for my subsidy portion for the month of April, with the late fees, which would have been
Rozak,
508. And I was going to ask.
hang on. Am I missing something? You are free to tell me, Judge, I see your point and I'm wrong.
No,
Am
I
I
don't think you're
missing-
missing anything, Your Honor. And like I said, I'm happy to extend to the end of the month. If that'll give
Oh,
Ms.
but
Himes comfort to
he
make
wants to
her
keep
make her
arguing
payment.
with me, and I
I
have no
know.
other way to do this. I'm sorry. I can extend this long enough for you to get on the phone and call him and say, send him the money. And
They're
I
not
can
going to
extend
send it,
it,
Your Honor,
ma'am,
until I
you're
make
gonna
my
keep
portion.
interrupting me now today. I just can
No,
tell.
sir. I was
I
just
love it when
trying to
people
explain, they're not
interrupt
going to
me.
send it until I send my portion. They're not going to
Ma'am,
pay it. I can't call them because they're not going to pay that portion, Your Honor, until I pay my portion. That's why I was trying to seek clarification on my portion. That's all, Your Honor. I'm not trying to argue. I just was trying to elaborate on the ledger. I'm not
I'm
arguing
gonna
with
give
you,
him a
sir. I would never
judgment
do
amount of
that.
2684.94, 2686.94. I'm convinced that between you and the agency, that is at least, I know you're shaking your head, but that's the amount that's at least owed. Now, I can extend the writ date. He's entitled to one on the 23rd, but I'll be happy to help you out here if you just tell me what you can afford to pay and when.
Can you please give me a breakdown of this 2686.84?
Go ahead, Mr. Jarozik. 2686.94, I think you told me, right?
Correct. That's the total. And what I did, Your Honor, and perhaps what I've done is when I took out some of those $75 late fees that I saw on the ledger. So what I show is rent retained possession of $2,290.25. 3 months of late fees at $50 each of $150. I have court costs of $246.69, which gets me to the total of $2,686.94, if my math is correct.
Okay,
And is
so
that paying me through April, Your Honor?
yeah, that would take care of everything through the end of April.
That's correct.
And 2290, can you break that down? How you got 2290? Is that 1450 times 2? Is
Well,
what I'm just asking.
that one's a little more difficult because the last zero balance I see is October of 2025. So there's been payments made here and there, so it's not a flat 2 months. We'd have to go back penny by penny for many, many months to get to the last zero balance to move forward to figure out
So
exactly.
I'll
what
tell
that
you how
amounts
I'm
to.
calculating it, ma'am. You told me that as of March the 26th, and you seem to adopt this, that the total amount that you owed according to the ledger was 1214.25. Whether you agree with it, like it, don't like it, I'm adding in the 1450 for the month, starting April 1, which brings the total to 2664.25 plus a $50 late fee, which would take it to 2714.25, and that doesn't even include your court costs or statutory attorney fee, which he just spelled out is another $396.69. So at the very minimum, you're getting a break here. Now, I'm going to order that, and I'm not going to argue with you. I'll invite you to tell me when you can pay. You're shaking your head. I hate when people shake their head at me. I just hate that. You
Because
want to get off here and tell everybody I'm the worst judge in the country? Feel free.
No,
I
it's
hate
not
that. That's disrespectful, and I'm
I
not going to argue
apologize.
with you anymore. I'm going
I
to try to help
apologize. I
you.
wasn't arguing. I was apologizing, Your Honor. I said I
You're shaking your
apologize.
head at me. You've been shaking your head.
Because they're going to pay them 1067 for each month they have in the past.
I mean, I get it.
And
I've already gone through
and
this
he's
with you
saying a
3
zero
times.
balance has been October, but I paid the 900 like when
I'm not reconsidering. I'm asking you to tell me when you can pay this so I can help you. If you persist in arguing with me about who's going to pay who, when, and how much, I'm just giving you April 23rd. Period.
I won't. Okay, Your Honor, would that include them making their payment of the 1067 through the agency for March and April through
Yes, that
April
includes
30th?
this payment. Yes.
Would that be, Your Honor, would that be subtracting from the amount that you're saying that I owe? Because I only owe what I tried to explain.
Yes. It would be subtracted. Absolutely. I'm not trying to stick you with this and then have them say they still got to pay them the 100,000 and whatever amount of dollars. This is all included. They're entitled to a judgment on the rent that's owed, whether as to what has not been paid. And that's what I'm trying to tell you nicely, and you want to just keep arguing with me. Can you pay
I'm trying to
all of this?
understand. I was trying to understand. What is the exact amount that you're saying, sir?
Can you pay all of this money, including the subsidy money, which you will be credited for, by April the 23rd or April the 30th? Can you
April
do that?
the 30th, but what is the full amount, Your Honor, that you're referencing? The 2290, Your Honor, 25?
No, 2686.94.
I have 1214 and 25 cents that was at the end of the ledger. Can I pay that tomorrow when I'm off?
This courtroom moment gets tense fast when a rent dispute turns into a direct clash between a tenant and the judge. She insists she owes less because of a housing subsidy, but the judge shuts that down, making it clear the full rent still counts no matter who pays it. As she keeps pushing back, the judge grows frustrated and calls it out. "I'm trying to help you, but you keep arguing." Then comes the breaking point. "I hate when people shake their head at me. That's disrespectful." And just like that, the flexibility is gone. In court, attitude can cost you everything. Like and subscribe for more courtroom moments.